So friends, Donald Trump's desperation is showing in an absurd new court filing that's based on politics, not law, and that is designed to keep hidden from the American voters the full scope of the democracy-busting crimes Trump committed on and around January 6th. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump and his lawyers just filed a 7-page brief in his federal election subversion case in D.C., and I've been trying to come up with just the right word to characterize this new Trump court filing, and frankly, I'm vacillating between absurd and garbage. Let's start with the new reporting, and then we'll turn to the three main arguments Trump and his lawyers make in this new court filing as to why Judge Tanya Chutkan essentially should not do what the Supreme Court has directed her to do. But let's start with the new reporting. This from HuffPost, a piece by Brandy Buckman. Headline: Donald Trump begs judge for more redactions in brief for January 6 case. With the clock ticking down to Election Day, the GOP presidential nominee wants to keep as much under wraps as he can. And that article begins, attorneys for Donald Trump lashed out in a court filing Tuesday, claiming that special counsel Jack Smith is attempting to usurp control of the defense and demanding more redactions in Smith's brief, laying out evidence in the former president's election subversion case linked to the January 6, 2021 insurrection. Trump's attorneys claim that Smith's brief was politically motivated and could influence the outcome of November's presidential election as Trump seeks to retake the White House. Quote, the special counsel's office wants their politically motivated manifesto to be public, contrary to the Justice Manual and long-standing DOJ norms in cases not involving President Trump. In the final weeks of the 2024 presidential election, while early voting has already begun throughout the United States, Trump attorneys John Lauro and Todd Blanche wrote in a 7-page motion. Trump has been accusing Smith of election interference since he was first indicted in the case. Federal prosecutors have pushed back on this assertion, noting that his initial indictment was made over a year ago. Smith last week filed a brief under seal laying out evidence that prosecutors say they can still use in the election subversion case following the immunity ruling. Okay, friends, let's go right to this new 7-page Trump court filing. I'm not going to read any of it because, like so many other court filings in Donald Trump's cases, it reads a lot like a 2 a.m. unhinged social media post by Donald Trump himself. But what I want to do is take on the three primary arguments Trump and his lawyers make in this court filing as to why Judge Chutkan, should not go with Jack Smith's redactions and, in essence, shouldn't reveal anything to the public. Here are the three main arguments they make in their new court filing. 1, Donald Trump and his lawyers complain that Jack Smith has changed his position. Previously, Jack Smith and the prosecutors didn't want evidence to be released publicly before it had to be, like when you're going to litigate issues or go to trial. And now they've changed their position. Now they want it released publicly. The response to a complaint like that from Donald Trump and his lawyers, the legal response is, duh, circumstances have changed. The Supreme Court returned the case to Judge Chutkan and told her, litigate these issues, Judge Chutkan. Look at all the evidence, hold hearings, public hearings, and decide which of Donald Trump's crimes might have been the official acts of a president, such that he should be immune from prosecution, and which of Donald Trump's crimes did not involve official presidential conduct, such that he can be prosecuted. He does not have immunity. This is expressly what the Supreme Court told Judge Chutkan to do. And by extension, Jack Smith is required, obligated, given the posture of the case, to give all the evidence to Judge Chutkan, which he has now done with some redactions, and said, I'm prepared to litigate these issues just as the Supreme Court directed. So, of course, Jack Smith changed his position. Before he was required to litigate these issues, he was going to keep all of the evidence under wraps until it was time to litigate motions, other motions, or go to trial. Now he's required to do what the Supreme Court told him to do. So Donald Trump and his lawyer saying, oh my goodness, he changed his position from he wasn't going to disclose evidence to he is disclosing evidence. Duh, that's what the Supreme Court is requiring. Second complaint that they make in this new court filing. They say, well, Jack Smith in the Florida federal prosecution, you know, the classified documents, obstruction of justice, espionage case, he wants everything sealed. The prosecutors want to keep all the evidence under wraps in the federal case in Florida, which has been dismissed, but it's on appeal. The 11th Circuit Court of Appeals will very likely reverse Judge Cannon's dismissal and send it back for trial. But they're saying this is an inconsistency. What? He wants to keep it all under wraps in Florida, but wants to make it public in D.C.? Again, same legal reply. Duh. First of all, the case in Florida doesn't involve presidential immunity because Donald Trump stole classified documents, including our nation's, national security secrets, and took them to, his third-rate resort in Florida, Mar-a-Lago, and he wasn't president at the time he committed all of these crimes. So there's no presidential immunity issue. So there's no litigating what might be an official act of a president or not. And there's no need for an evidentiary hearing, so there's no need to unseal, to make public that evidence. Not to mention, you don't want to make it public anyway because it's classified information. So again, it's an absurd argument to say Jack Smith is being inconsistent when you compare the D.C. case to the federal case. Talk about mixing, apples and oranges. Third complaint by Trump and his lawyers, and this one's a doozy. They say, Judge, if you start releasing this evidence, there are witness security concerns. We don't want the witnesses to get hurt or to be threatened or to be harassed. Okay, this is the death of irony, friends. Donald Trump is just concerned with the safety and security of the witnesses who provided incriminating information and evidence against him. Doesn't want any harm to come to them. This is the same Donald Trump, the same defendant in the case who had to be gagged to stop from saying and posting things that endangered the lives of the witnesses. But they now are arguing that, oh, Judge Chutkan, please don't release this evidence. We have witness security concerns about the witnesses who incriminated Donald Trump. And our concern is if their names and information gets out, that the Donald Trump supporters, his MAGA folks, will get after them. That's why I was vacillating between characterizing this court filing as absurd and garbage. It frankly qualifies as both. The good news, friends, is with such an absurd pleading being offered in response and as an objection to what Jack Smith has proposed, it's going to be easy for Judge Chutkan to say, okay, I've assessed your positions and they are meritless, so I'm going to go with Jack Smith's proposed motion with redactions, and I'm going to order it be placed on the public document so we can get this litigation underway. This one is a fairly easy call, I suggest, for Judge Chutkan to make, And I think we are very likely going to see much more information and evidence by virtue of this document being made public about Donald Trump's crimes, which, yes, will further reinforce why he has no business being within 1,000 miles of the Oval Office. And I think Judge Chutkan will get this call right. Because justice matters. Friends, as always, please stay safe. Please stay tuned. We may have information about this very soon. And I look forward to talking with you all again tomorrow.